So thank you, Josie, for the introduction, and welcome everyone to today's Ius Laboris webinar. So as you yourself may have experienced, in the last couple of years, employers have struggled a lot to find workforce. This seems to have been determined by a number of different reasons. On one hand, at the beginning, limitations connected to the COVID pandemic and the difficulty of movement was a reason. Then, and still now, we have experienced the Great Resignation phenomenon. So employees who are resigning because they are no longer happy about their life, their work-life balance. And also employees generally are asking for more flexibility. They have different expectations from their work life. On the other hand, employers have realized with COVID that many activities can be carried out remotely. There is no need to have employees there and to check how they carry out the work activity at the office. So employers, I think, and I think that is also your experience, has started looking abroad sometimes to find candidates if they cannot find employees in their country with the skills they look for. So today we will addressing the topic of satellite employees. Satellite employees is a definition we have given to these employees who are hired by an employer of a certain country, let's say, by example, Italy, and these employers hire an employee who is in another country. So by way of example, Germany. So the employer does not have a legal presence in Germany, but it allows the employee to work and continue living in Germany to even accommodate the employee's request. Now, this is very useful for employers because it broadens the pool where to find candidates from. But of course, there are a number of issues that have to be taken into account when hiring these satellite employees. So you will have to evaluate how you can proceed with the hire in the country where you do not have a legal entity. You will have to evaluate which is the applicable legislation if you have to take into account the legislation of that country. You will have to take into account social security aspects, tax aspects. So the aim of this webinar is to shed light on this new phenomenon of the satellite employees and to give you some inputs so that you can better understand what you have to take into account when you decide to hire a satellite employee in another country. To do this, we have formed this panel of Ius Laboris colleagues. So I'm Melania Soncin. I am a senior associate at Toffoletto De Luca Tamayo in Italy. And with me, I have the pleasure to have Sophie Maes, who is a partner at Claes & Engels, our Belgium law firm of Ius Laboris, and who is also the chair of our Global Mobility Expert Group. We have Roberta Papa, who is co-founding partner at Blasi Papa in Switzerland. And we have Amy Navins, who is a senior associate at Louis Silkin in the Employment, Immigration and Reward Division. So let's get started. The first topic, throughout the webinar, we will address different aspects of hiring satellite employees. The first topic we will address is how should an employer proceed when hiring a satellite employee? At the beginning, what are the administrative steps it has to follow to hire a satellite employee? So Roberta, let's start from Switzerland. You're on mute, sorry. Still on mute?
I'm on mute now. Thank you, Melania. So now, from a Swiss law perspective, it is not necessary to establish a legal entity or registered branch in Switzerland. It is perfectly allowed to employ an individual directly through a foreign employer. And as you said, we're talking about situations where the employee typically resides and regularly works in Switzerland. And this means that there will also be social security and possibly tax implications to consider. In particular, the foreign employer will have to contribute to a social security system and take out employee insurance in a country whose rules the employer is not familiar with. But these administrative hurdles can be well managed with a good local payroll service provider. However, when planning satellite employment, employers must allow enough time to this aspect, and we regularly see that this is not taken into consideration sufficiently. Because in practice, namely putting in place the necessary employee insurance will take some time. Now, there are foreign employers who would like to avoid all these administrative tasks and who therefore consider engaging an employer of record. The term employer of record is usually applied to companies that act as formal employers and then put their employees at the disposal of another company that manages the day-to-day relationship and acts as factual employer. Now, under Swiss law, an employer of record will therefore generally qualify as personnel leasing company. It is permitted in Switzerland to use employer of records, but you have to comply with restrictive provisions of the Swiss Personnel Leasing Act. Amongst other things, this means that the employer of records must have its registered seat in Switzerland and obtain the required license for lease of personnel. Note that lease of personnel from abroad is prohibited. Therefore, in order to employ a satellite employee in Switzerland, you must not engage an employer of record with registered seat abroad. This prohibition to lease personnel from abroad also applies if the foreign employer of records recruits the employee in Switzerland. So it's still a cross-border situation that is not allowed in Switzerland. The employer, this is important, the employer risks being fined if they contract an employer of record with registered seat abroad to employ an employee in Switzerland. But let me say it again, a foreign company that wants to employ a satellite employee in Switzerland does not need an employer of record to do so. A direct hire is possible, and with a good local payroll service provider, the administrative hurdles can very well be managed.
Thank you, Roberta. So, Sophie, as regards Belgium, do you have these two options, so the employer of record and the direct hire? And what are the challenges that usually your clients face when trying to hire a satellite employee?
Well, Melania, as regards Belgium, direct hire will be your only legally compliant option. Because it's a bit the same as in Switzerland. In Belgium, you do not need a legal entity to employ a foreign or to employ an employee in Belgium. Also, you do not need a branch. So it's the same as in Switzerland, because also registrations may be due for Social Security and taxes, but they can all be perfectly managed by a good payroll office. But what is, on the contrary, forbidden in Belgium is making use of an employer of record, because also in Belgium that qualifies as lease of personnel. And in principle, lease of personnel is forbidden in Belgium. So it's a bit the same definition. It refers to a situation where a foreign employer or where a formal employer, in our case here, the employer of record, puts an employee at the disposal of a user company in Belgium, which would then be the foreign Italian employer, so to say, who will be the material employer of that employee, manages that employee, gives instructions, etc., etc. That situation is forbidden under Belgian law. So the question is, of course, what are my risks? What happens if I do use an employer of record? Well, first of all, there are criminal penalties and also administrative penalties for both the employer of record and also the user company. But more importantly, the employee is considered to have an employment contract with the user company. And also the user company, so a foreign employer, becomes jointly liable for all remuneration, benefits, social security contributions, etc. So in a nutshell, everything why we would want to use an employer of record, it makes no sense, because at the end of the day, you're liable anyway. So that is why a direct hire is the only legally compliant option. There are some exceptions in relation to prohibited lease of personnel, but they cannot apply here because it refers to intra-group leasing, etc., etc. The only other alternative that you can consider, but that's completely other story, is when the person would work as a self-employed contractor, but then we come into the debate, is that a genuine self-employed relationship, or is that a fake self-employed person? So in a nutshell, direct hire is our only option if it is an employee.
Thank you, Sophie. I think we can copy that for Italy. It's the same. So Amy, what about the UK?
Yeah, so direct employment can be used in the UK as well as using an employer of record, a contractor, or agencies. We are not regulated, and you don't need permits in the UK to use an employer of record. We're a little bit freer, perhaps, in terms of the options that you can take. I think it's useful to understand when we've spoken about the need to consider tax and social security, sort of how you would deal with that logistically. And this applies in lots of European countries, although the process is slightly different. But generally, what you're doing is you're registering as an employer your overseas entity with the country where the employee is going to be working. So, for example, if you're an Italian business and you want to hire a UK-based employee, you don't have a UK entity, you would register the Italian entity with the UK Social Security and tax offices as an employer. And that's completely different to setting up an entity or a branch. You're literally just assigning yourself with the relevant authorities that you are a foreign employer. And by doing that, you generally get a number or a registration, which enables then you to make the payments to the local authorities in terms of any income tax withholdings or any social security withholdings that have to be made. So that's sort of the process of how you do it. And it's very important to note that it's very different to setting up an entity or setting up a company overseas. The cost varies across different countries, and the time frames varies as well. Some countries you can do it very quickly, others it takes up to 6 months to register with these authorities, and the cost can be in the thousands or very low, and you generally use sort of an accountancy firm or something like that to help you with that process. And then what you need then is a local payroll company who can help you, because most of your home payroll functions won't have the ability to operate across numerous countries and understand the different taxes and things like that. So you generally use an international payroll company who can make all the calculations for you, create the pay slips, and then you make the payments yourselves. So that's how it works logistically. Even if you can do that, which in all the countries spoken about today you can, the key consideration that you really need to be thinking about early doors when you're looking at a relationship like this is whether you're going to risk setting up a permanent establishment overseas. So this permanent establishment is a corporate law principle. It's not something that generally employment lawyers advise on, but it's always something we flag when we look at these overseas arrangements. And effectively what that means is if you have an employee, using my example of an Italian company having a UK-based employee, if you are seen as operating a permanent establishment, a business properly in the UK, then you will be, for corporate tax purposes, potentially liable for corporate tax on the profits attributable to that permanent establishment in that country. And you'd have to comply with your reporting and other obligations in relation to that. Now, generally, globally, countries follow the same sort of guidance on corporate tax, but there are niche differences. India is one, for example, that's very different. But generally, it depends on how long someone's in that country and the type of role they're doing and the number of employees that you have. So you've got a cumulative permanent establishment risk when you've got lots of employees working from there. They might be not senior, but you've got lots of people working there. They're working in the local economy. That could cause you a risk. But also if you've got someone who's very senior, so they're going to be a director level or a senior non-executive director, so they might be not on your board of directors, but they have very senior roles, that's going to potentially cause you a risk. And the same then if you've got someone who works in a sales role who's going to be concluding contracts overseas, and that's your risk there. So you not only have to consider what type of employment model can you do, one of your very first considerations needs to be that permanent establishment risk. And it's really something you need to bring in your finance team to help you with, because it wouldn't be something you'd expect your HR or legal team to be able to advise on. You need your finance team, because they may well have a corporate tax strategy overseeing your whole group business, for example, and we wouldn't want to potentially get in the way of that by having a rogue employee working overseas.
Thank you, Amy. This is very interesting. So let's pass to our second, topic for today on satellite employees, which is the applicable legislation. So within the European Union, we have common, rules on applicable legislation because we have Rome I regulation, which in a nutshell states that even if the parties are free to decide which is the legislation applicable to an employment contract, this cannot deprive the employee of the mandatory rules applicable based on the legislation of the country in which the employee is habitually working from. So you can understand that this may be the case with a satellite employee. In this context, Sophie, what would be your advice to your clients when they have to draft the employment contract for a satellite employee?
Well, Melania, as you said, in that situation for satellite employees, Belgium law will be applicable. So we would usually advise to really draft the employment contract in accordance to Belgian law. That being said, but you also already indicated, the parties could perfectly choose to say, well, actually, I don't want to follow Belgian law because I'm used to follow, let's say, the law of my own country. I will apply French law to that contract. Imagine that we are talking here about a French employer. From a legal perspective, you could perfectly do that. But the problem is that the employee can always invoke the mandatory Belgian laws because Belgium is his place of habitual employment. And Belgium employment law, to make it short, almost everything is mandatory. So actually, if you choose for the law of another country, then you come into a situation where the employee can just pick and choose whatever is best for him. So that is why, from an employment perspective, we would always advise, please choose for Belgian law, because whatever you do, you cannot avoid it. And you may even end up in a very tricky situation, for example, in case of dismissal. Because to make a long story short, Belgium dismissal laws are extremely expensive. It costs a lot of money to dismiss somebody with us, but we are quite flexible. If we compare it to other, and especially our neighboring countries, it is quite easy to dismiss somebody. So the big question is then, what is more advantageous? Is it the fact that we pay you a lot, or is it the fact that you are more protected? So we end up in a long discussions, etc., etc. You avoid it, just choose Belgian law as the applicable law to the employment contract, because you cannot avoid it anyway, because it will apply. Besides the Belgian laws, you will also need to follow our collective bargaining agreements. And we have different types of collective bargaining agreements. You have national collective bargaining agreements, which apply to any employer employing employees in Belgium, but also sector CBAs. And a sector CBA, that refers to CBAs that are concluded in a sector of industry. And those also apply to satellite employees, even if the employer is not part of a employer's representation that has concluded the CBA. So the big question, the next question is then, which sector should we follow? And there we need to look at what is the employer's main activity on Belgian territory, which basically is then what is the activity of the satellite employee. And in most, which will not necessarily be the same as the main activity of the employer as a whole, but we need to look at what happens on Belgian territory. And in most cases, that will be what we call Joint Labor Committee, because that is how we call it, or sectors 200. And in that committee, you have CBAs, which are mandatory. And for example, with minimum wages, with the 30-month premium, with automatic indexation, which is also, which was especially this year a huge surprise, because mandatory indexation in the Joint Committee 200 was 11.08%, so also applicable to satellite employees. And it also has an impact on your payroll structure, because if there is a 30-month premium, you need to pay salary in 30.92 installments and not in 12 installments. So that is in relation to the CBAs. Other important thing to note in Belgium, language rules. You may know that we have 3 official languages and we like to protect them. And we have very strict rules in Flanders and in Wallonia, because everything in Flanders has to be in Dutch. In Wallonia, it has to be in French. If it is not the case, then it's simply null and void. So that is also a thing to consider, that you might need, you have to make sure that you do everything in the correct language. If the employee is living in Brussels, because you need to look at the place where the employee will be living and working, you have more flexibility, because in Brussels, the penalty is not that the documents are null and void, but the employee can just ask for a version in the appropriate language. Some last giveaways. We don't have a trial period in Belgium. We abolished that, and that's the reason. The reason, therefore, is that our notice periods are very short in the beginning. And then the last one, I would say, non-compete clauses, you need to pay for them in Belgium. So that's also something that you might need to know if you want to enforce them. In most of the cases, you will need to include an indemnity.
Thank you, Sophie. So contracts have to be drafted, I would say, carefully. So Roberta, Switzerland is not in the EU, although we always forget because you're there in the middle. So the Rome 1 regulation we spoke about is not applicable to your country. But what does this mean? Can the parties choose applicable legislation?
Yes, they can. In fact, they do not have to subject the employment agreement to Swiss law. Based on conflict of rules, they can also choose to apply the laws of the country where the foreign employer has its registered seat. However, a Swiss law may be more favorable than foreign law, as it often proves to be far more flexible for employers. We've now heard what Belgian provisions exist and apply. So we are quite flexible for employers, especially when it comes to termination of employment. But regardless of the law governing the employment agreement, there are some aspects of mandatory Swiss law that will still apply. And we're talking about rules on health and safety at work, maximum working hours, rest periods, night, Sunday work, mandatory overtime pay. And in addition to that, we also have collective bargaining agreements that might apply sector-wise if they were declared generally applicable. And such CBAs and also standard employment contracts sometimes set mandatory minimum wages that foreign employers must comply with. And also Swiss cantons, some Swiss cantons have introduced quite recently minimum hourly wages that have to be observed, and probably they're quite high compared to other countries. They are each around 20 francs per hour.
Thank you. Yeah, this is higher than Israel. So going back to the drafting of contracts, Amy, in my experience, we often have UK clients contacting us for Italian employees. And in my experience, your templates are very long. So if a foreign employer has to hire a UK employee, what do they have to put in that employment contract?
Yes, UK contracts are often quite lengthy, although I understand that our European colleagues are following suit and are going to be having quite lengthy contracts as well moving forward. But yes, they are quite lengthy. Although the reality is there doesn't have to be that much legally within an employment contract. There's a specific section of our legislation, Section 1 of the Employment Rights Act, which sets out what needs to be in a written statement of terms for every single employee, and it has to be given to them before or on their start date. And it's got to be in a single document. And it includes general things you probably already would give anyway. So the name of the employer, name of the worker, dates of the employment commencing, rate of pay, hours of work, holiday entitlement, benefits, notice. I'm not going to read all of it, but you can look it up on legislation.gov.uk and it sets out everything that needs to be in there. But you need to have all of that within the employment contract. But then some information you can have in a separate document, although it's commonly all put into one, hence why the employment contracts become quite lengthy. But you can have sick leave and pay, other paid leave entitlements, pensions and pension scheme details, collective agreements, training entitlements, and disciplinary grievance procedures. They can be kept separately out of the main employment contract. In terms of the contract still not needing to have masses of things in it, we would still recommend that you put in other clauses. For example, especially with a satellite employee, clarifying where they can work. So they're allowed to work in their satellite country, but no other country. Anything around home working, because invariably these people will work from home. Governing law and jurisdiction clauses, because as we've spoken about, that's going to be potentially a tricky topic. So you want to have it really clear as to what law is applying and what jurisdiction will disputes be brought into. Data protection, that's going to be a tricky one as well. So although you don't need to have these clauses in, you would want them, and there's certainly extra things like around a place of work that you need to think about a little bit more when you've got a satellite worker than you would maybe if with a general home employee. And then just looking at the questions, there's something about applicable CBAs and things for different countries, but just in the UK, there's generally no national CBAs or anything along those lines. It would be more if your employer has agreed them. So again, we're a little bit easier. And again, in the UK, you can pick whichever jurisdiction applicable law, but we would always say pick the UK, very similar to Sophie. It's just far easier.
Thank you, Amy. Yeah, we'll maybe go back also to the questions at the end and may give a comment also for Italy if we have time. But I would like now to first address our third topic for today, which is policies, because as we said, there is employment contract, applicable legislation, which has to be reflected in the employment contract. Often employers we often recommend to employers to also draft certain policies, which are important to have, let's say, according to local legislation, because foreign legislation may clash with the local applicable legislation. So Amy, as regards the UK, I understand that you have several kinds of policies which are quite peculiar.
Yeah, so in the UK, we don't necessarily have a whole suite of policies and procedures that you have to have in a company handbook, for example, which I think one of our other countries on the panel will say something differently later on. But we will still have recommended policies that you have in place, and that's things like whistleblowing, parental leave policies, so maternity, paternity, shared parental leave, expenses policies, disciplinary and grievance policies if they're not in your contract, sickness absence policies, data breach policies, and equal opportunities. They're sort of your standard ones you'd expect to have. And oftentimes, if you've got a overseas entity that would normally have a policy or a handbook, you can do what's called localizing it. So we take your handbook from your home country and we just tweak where we need to make sure it complies with UK legislation or elsewhere. So that's often how we do it. Again, they're not compulsory, but we would recommend that you have them in place. However, once an employer has 5 or more employees in the UK, they are required to have a health and safety committee and a policy which sets out how an employee can raise concerns and who the health and safety executive, who's sort of our inspectorate, can come and contact regarding issues. Now, this committee can just be one person, so it can be your one satellite worker, or what I imagine the most common is that an employer can engage what's called a competent party. So it's an external health and safety company who, for a fee, will take on that role. However, they don't take on the liability. So the liability for compliance still sits with the proper employer. They just take on some of that accountability in terms of being contacted by the HSE, etc., and for the employee to raise concerns with. There's also a consideration with regard to different types of insurances. So this is not your normal social security insurance that we spoke about previously. UK legislation says that every employer carrying out business in Great Britain has to insure and maintain insurance under one or more approved policies with an authorised insurer or insurers against liability for bodily injury or disease sustained by employees arising out of the course of their employment in Great Britain and that business. And the Health and Safety Executive's guidance confirms that if you have an employee working continuously for 14 days in Great Britain, then the employer needs to have employer's liability insurance for these employees in the UK. And the policy has to cover for at least £5 million worth of damages, and it has to come from an authorised insurer. Now, employer's liability insurance only covers employees, and most employers would also have a public liability insurance as well, which covers other parties. In terms of your employer's liability insurance, if you don't have it and the HSE inspects or finds out, then the employer can be fined £2,500 for every day that they're not properly insured. and also £1,000 if they don't display their employer's liability insurance and inspector, or give it to an inspector when they request it. So that's quite a big task for you to do. And also, because you're a foreign employer and you're not going to have a base in the UK or an entity in the UK, you will have to use a specialised broker. It's not impossible, but it's just a little bit more tricky. So again, make sure you give yourself enough time to set that up if you need to. In general, in the UK, employers have an obligation to protect the health and safety and the welfare of their employees. You have to make sure that your employee has a safe working environment without any sort of risks, and that their facilities are safe, and that the arrangements for their welfare in work are sufficient. Now, you normally do that by carrying out a risk assessment on the work activities the employee is going to be doing. You'd identify any hazards and the degree of risk, and remove any of those hazards to minimise those risks. And there's lots of guidance the HSE, so our health and safety executive, have provided on home working, which, as I said earlier, generally is going to be the case for these satellite employees. Dependent on what employees do, there's different guidance and requirements, but I'm not assuming anyone here is working with harmful chemicals or anything along those lines when they've got home workers, so it shouldn't be too onerous. There are some pieces of legislation in the UK specifically for people who work with computers and display equipment, and also people who work on their own. So there's definitely things that need to be complied with, first aid provisions and things like that. So that's something that you'll need to think about, which I think often is overlooked when you have these satellite employees, because you wouldn't normally expect an employee working from home to have all of these potential risks and obligations, but they will be a lone worker. Their place of work will be home, it will be in a different country, so you will have some additional obligations there.
Thank you, Amy. I will now give some insight also for Italy on policies. One document I really want to stress, it is important to have in Italy, is the disciplinary code. Going back to UK companies, what I often see is that UK clients want to apply their rules, their grievance policies, their disciplinary policies and procedures to Italian employees. The problem is that in Italy, we have very, very strict rules on how a disciplinary procedure has to be carried out, how it works, which sanctions can be applied. You cannot decide which is the applicable sanctions. Sanctions are only the oral or written reprimand, the fine, the suspension, the dismissal. You cannot transfer an employee as a sanction. And also the procedure is very strict, warning letter, justifications, sanctions. You cannot go and mix this with a grievance procedure, which you would do before, but then you go and already hear the employee, while you should hear the employee only after you have issued a warning letter. It's a mess. So if you're a foreign employer and you have an employee in Italy, you have to have this disciplinary code in which you write which are the behaviors that may trigger the application of a disciplinary procedure, which are the disciplinary sanctions, and which is the disciplinary procedure based on Italian law, and if you apply one, the collective bargaining agreement applied. This document has to be posted in a place which is accessible to all employees of the company. Now, if you have a satellite employee and maybe you do not have an office in Italy, make sure that this document is shared with the employee. You have proof of the fact that you have shared it with it. And if instead you do loan an office, this document has to be posted within the office. Otherwise, the risk is if you apply a sanction or worse, dismiss the employee based through on disciplinary grounds, this may be unlawful and the consequences can hurt. So this for Italy. And Sophie, what would you say about Belgium? And also as regards health and safety, which Amy touched upon.
Well, we also have something. It's quite similar of in Italy, but a bit different as well. What we have is every employer, also if you only employ one employee in Belgium, must have what we call work rules. And you can compare that with an employee handbook, although it must include some mandatory provisions according to Belgian law. And what it must include are, for example, what are the work schedules, but also a bit similar as what you were saying, what are the sanctions and what are the acts they are sanctioning? Because you can only impose those sanctions for those acts which are included in the work rules. And if you don't have work rules, well, you cannot impose disciplinary sanctions. Other things that must be in there that relates more to health and safety is procedures for psychosocial risks, etc., etc. But what is quite particular, I would say, for Belgium and for those work rules is that they have to be adopted and implemented by following an information and consultation procedure. So it's a whole procedure that you have to follow, even if you only have one employee. And afterwards, you need to send the work rules for registration to the social inspection. So it's also quite cumbersome, and you don't have that much flexibility as an employer. So what do we recommend in practice? And that is not only applicable to satellite employees, but also to companies with 1,000 employees in Belgium, is to limit the content of the work rules to strictly legally minimum and put everything else in separate policies. Just because everything you change in a work rules, even a comma, you have to go to a information and consultation. I'm exaggerating a little bit, but you have to go to information and consultation as soon as you want to change something in the work rules and register to the social inspection. So therefore limit that to the strictly minimum and put all the other things in separate legal, separate policies, because there you don't have to follow this specific procedure. So that is a mandatory thing, so the work rules. The second thing, quite similar as in the UK, also but with one employee, because I understood in the UK it's with 5 employees, you have to have an internal service for prevention and protection at work. But if you don't have it, you can call on an external one, and that is actually in practice what happens with satellite employees. So you need to affiliate and to an external service provider, but we would normally recommend to take this up with your payroll company, because they usually work together with appropriate external services for prevention and protection at work. You also need to carry out a work accident insurance, but also there we would advise take that up with your payroll office. And then also a bit similar as in UK, you need to do a risk assessment from health and safety perspective. And then of course also because the way the employee is working must comply with the requirements of a computer workstation. So we have minimum requirements in relation to how the chair must be, how the desk must be, how the keyboard must be, the screen, etc., etc. So that's a bit in a nutshell how it is in Belgium.
Thank you, Sophie. This actually, your last sorry, do you have something?
No.
Okay, thank you. This brings me well to our fourth topic today, which is remote working. Because if you are a foreign employer who has 1, 2 satellite employees in a country and you do not have a legal entity there, it is highly likely that you do not want to, let's say, lease office spaces. You would like to allow the employee to work remotely, maybe from the employee's home or from wherever the employee wishes to work from. And the issue is, can this be done? Who bears the costs for this remote working? As regards Italy, we have 2 kinds of remote working. One has been there for ages. It was not in the law, comes from collective bargaining agreements, and it's teleworking. Teleworking means you, employee and employer, you agree on where the employee will be working from, usually home. So then the employer goes at the employee's home and sets up the workstation and checks that everything is compliant with health and safety regulations. And the employee has to work from there. Now, this has been not much used, this teleworking arrangement, throughout the years. And as I said, it's not even in the law, it's only in collective bargaining agreements. But in 2017, government decided to introduce a different kind of remote working, what we call smart working. So what is smart working? Smart working is more flexible, both for the employer and for the employee. Why? Because the parties may agree, so the employee will work a bit at the company offices, a bit outside, parties can, he or she is often given the freedom to decide where to work from. So it's not as if there is one place of work which is outside the company premises. The employee can go and work from the seaside, from the mountains, wherever, within, let's say, the limitations agreed upon in the smart working agreement. So employee, please do not go and work in the park because you are, let's say, processing probably sensitive data of the employer. Now, smart working is more flexible also as regards health and safety, because given that the employee may move around, the employer does not need to chase the employee to set up a workstation each time, but just needs to give a notice to the employee describing which are the common general risks relating, which come up when someone is working outside the company premises. So as you see, it's easier. Also, as regards costs, while in teleworking, the employer has to take care of all costs related to the use of tools, electricity, and so on, based again on how it is regulated in the specific collective bargaining agreement, but this is more or less a rule. In smart working, this is not mandatory. So it's up to, let's say, the negotiation between the parties. Now with COVID, everybody used smart working. It has really changed completely how we work in Italy, as I think throughout the work, remote working more generally. So nowadays, this smart working is very common, and I think it fits with the satellite employee, given that it frees the employer from the obligation to, let's say, loan an office space in Italy. So Roberta, what about in Switzerland?
Well, in Switzerland, there are not specific regulations governing remote working, or at least not yet. So the usual principles of employment law apply. And one important aspect, of course, is costs and equipment. And according to mandatory principles, the employer is obliged to provide the employee with the necessary work equipment and materials, the computer office equipment and so forth, or to reimburse the employee if the employee provides his or her own equipment. This aspect can be stipulated differently. We'll see that this is different when it comes to costs, but equipment can be charged upon the employee if the parties agree that it's the employee's responsibility. So that's possible. But when it comes to costs, the necessary costs arising from work performance, there we have a strict rule according to which the employer has to bear all necessary costs arising from work performance. And now when we talk about satellite employees, the question is having a home office a necessary cost or not? And this strictly, of course, depends on whether the employer puts at the disposal of the employee a local office. If this is not the case, then the costs arising in the home office of the satellite employee must be regarded as necessary costs, and the employer has to pay for those. So reimburse costs for electricity, telephone, internet, even rental costs. It is possible to agree on a fixed expense allowance, but also this expense allowance must at least on average cover all necessary costs. On the other hand, if there is local office and the employee just prefers to work from home, then you can argue that these costs are not necessary and the employer does not have to pay for those. There was an interesting decision on the compensation of rental costs that was rendered by the Swiss Federal Supreme Court in 2019. It was the pre-COVID area, so we don't know how they would decide now. But in the case examined by the court, there was in fact an employee that worked for an employer who did not provide a workplace in its offices, and the employee always worked from home in a room that was also used as the employer's archive. Now, the employee claimed compensation for the use of this private room, and the Swiss Federal Supreme Court confirmed this claim and awarded the employee a compensation of 150 francs per month for using the private room for business purposes. Now, the facts were quite specific because it was not only an office, but also an archive. But it shows that according to the Supreme Court in Switzerland, even a relatively low amount may be considered sufficient to compensate the employee for the use of a private room for business purposes. Now, apart from provisions on costs, there are, of course, other rules that apply. We've talked about health and safety. Of course, it's also an obligation of the Swiss employer to make sure that the office meets the health and safety requirements, and they have to verify, or at least ask for explicit confirmation by the employee that the minimum standards are met. But the employee must also respect maximum daily working hours, mandatory breaks, rest periods, and so forth. And the employer should make the employee aware of these rules. And furthermore, of course, it's very advisable to agree on the place from which the employee may work. Is it really only the home? Or can it also be a holiday home or a public space, depending on sensitivity, as you mentioned, Melania? And the question is also, of course, shall the employee be allowed to work from abroad, from another country altogether? This is an important aspect because work from abroad might, of course, have an impact on the social security situation of the employee.
Thank you, Roberta. So, Amy, what about the UK? How do you handle remote working?
Yeah, so in the UK, we don't have any specific rules relating to remote workers and the costs arising from that. However, it would be very common that if you were having a new recruit employee, for example, in the UK, and they were going to be entirely working from home, it'd be very common for you to provide them at least with a laptop, for example, and then usually a chair, a desk, etc., the necessary equipment for them to carry out their role. Sometimes this is provided directly by the employer in terms of they will just send a lorry who will arrive and the equipment will be given to them, or sometimes the employer will be given an allowance and they're able to go out and buy certain equipment themselves and then expense it back. However, be aware that if you go through the expense process, that could have an impact on some tax there. In terms of the cost of Wi-Fi, electricity, it's not the norm in the UK for that to be covered by the employer. You would expect those costs to be just incurred by the employee, and you would normally have that written into the employment contract to make that really clear as well. Especially if you have an employee who maybe has relocated to the UK because they might be used to other jurisdictions and different positions there. As with Switzerland, when working from the UK remotely, even if you pick an applicable law of a different country, there'll be mandatory laws that will apply to the employee who's working from the UK, and that will be the same in terms of the minimum working hours, maximum working hours, sorry, mandatory rest breaks and rest periods, night work. You mentioned health and safety regulations there. So those will all have to be complied with as well, which can be a little bit tricky if you've got HR who work, for example, exclusively in Italy and aren't used to dealing with an employee in a different jurisdiction. They'll have to gen up a little bit on their position overseas. And the same thing that we've mentioned before, definitely we would advise that you stay where they can or cannot work. And I would certainly be saying you cannot work overseas without having permission beforehand, but there might be a different view from my colleagues on that, only because that just opens you up to some tricky issues later on.
Thank you, Amy. So I see we are already receiving several questions from our audience. So I think I will leave now some room to these so we can have some discussion. So Sophie, the first is for you. So I will read it out for the benefit of everyone. So thanks, I am amazed by the similarities between Belgian law on employers of records and lease agencies and Venezuelan law. So this is a colleague from Venezuela who is writing. Basically, if you hire an employee through an intermediary, it would be considered an employee of the user. These regulations are little enforced though. On the other hand, we're coming across many foreign companies with no presence, hiring remote workers based in Venezuela through independent contractors, which really classify as employees. Sophie, what do you say on this?
Sorry, I was still on mute. Perhaps two comments. First of all, a comment these rules are not so much enforced. So first of all, also in Belgium, there are two types of sanctions. First of all, it is criminally sanctioned. So the question is then, is that regularly enforced? I'm a lawyer, so I will never say never, but it could happen. But I think the main risk here, what you always have in general with prohibited lease of personnel is, especially if you're employing a more senior employee and not social dumping, whatever, is also the risk from the employee themselves. Is the risk that the employee themselves can say to you, well, actually, I'm your employee. My employer of record is not paying my salary correctly, so you have to pay to me. And I also note that you have this and this and this in your company. I also want it. So I think that is, even if it is perhaps not enforced by the authorities, can also be enforced, so to say, by the employee themselves, who will make employment claims towards the employer. So that would be my first comment. My second comment on self-employed contractors, I think that's also a phenomenon that we also have, because in particular in Belgium, we have very high Social Security contributions for employees and much lower for self-employed contractors. So the magical solution is then we will employ them as a self-employed contractor, but then of course they must be genuine self-employed contractors and genuine, not subject to employee authorities. And there is sometimes where it doesn't fit anymore in the whole storyline, and they are actually fake self-employed employees. And that, I would say, the conclusion is the same. The risk is by the authorities if they see that there is somebody. And how can they see that? Most often it happens when something happens. If there is an accident and things like that, then is when everything comes out. Oh, there is an employee here, and where is he? He's not in our systems, etc., etc. That's a risk. And then the second thing is, again, the person themselves. Because what happens then, you enter relationship, and then the person say, as a self-employed, I have nothing. If I am an employee, remember, our dismissal rules are very expensive. Dismissal contributions are very expensive. They say, well, actually, I can claim a huge indemnity, and I have never been paid a 30-month premium. I have never been paid my holiday pay, etc., etc. So it's always two. You have to look at it from two sides. It's on the one hand the authorities, but it's also the person itself that can claim a lot if things are not properly organized.
Thank you. I will also answer a question for Italy, and then do a comment on the NCBA on the question which was there made before. So the question is a question for Italian workers for Italy. So Italian workers under fully remote regime, teleworking, what is the legislation on local festivities? By way of example, Sant'Ambrogio in Milan. Is this determined by where the employer headquarters is or where the employee is? E.g., a company with headquarters in Milan, an employee works 100% for home in Rome, thanks. So this example is fully Italian, but I think it's applicable also for satellite employees. The point is for who's not Italian. In Italy, we don't have only holidays like Christmas. We also have the patron saint holiday, which is a holiday of the saint of the town where you live, which changes from town to town. So in Milan, it's on 7th of December. In other towns, it's different dates. So what we usually do when the employee, either because the employer is in Italy but in a different town, or the employer is abroad and the employee is a satellite employee, is we specify, so if it's Italy, depends on the place of work of the employee. If you put place of work Rome, of course, it will be the patron saint of Rome. If it is a remote worker which works a bit in Milan or a bit in Rome, or has a foreign employer in Belgium but works in Rome, what we do is usually to specify in the contract that for administrative purposes, we will consider Rome as the place of work. And then the employee can even, if he's a smart worker, choose to work in the mountains a bit, in the seaside a bit, but we will not go and change the applicable festivity, because we will have clarified in the contract that for administrative purposes, we will consider Rome. And this has also tax consequences, because there is a small tax which is paid based on where you live, which takes into account cost of living. So also for this purpose, this is important. And another question I wanted to answer on collective bargaining agreements. which was made a bit generally to everyone. How do you handle collective agreements, entitlements, or other specific entitlements from the home country if you apply the law of the country of the remote worker? I would like to clarify, even if no one will believe me, that collective bargaining agreements are not mandatory in Italy. If you do not have employees already hired with a collective agreement, if you're not registered to a union association, you may draft an employment contract without applying a collective bargaining agreement. So, of course, this may give a bit of a headache to your payroll, but it can be done. So always first, let's say, speak to your council and assess if and what collective bargaining agreement it's better to apply. So I think we are running out of time. I would like to leave the floor to Sophie now, who is, as I said, the chair of our Global Mobility Expert Group, because we have really been working a lot on your guidance on this, on global mobility this year. So you can also present our audience what we've been doing.
Yeah, I'm very sorry. I'm abusing a bit of the time here. So I would like to make some promotion for the things that we have made in our expert group. But the good news is it's all for free. So it's not paying. So we are very happy to show to you, because we hope that it may help you in deciding and organizing and managing your employees globally. So one of the things we have done with our expert group is exactly drafting a practical checklist for hiring satellite employees. And I must say, I'm taking the word here, but I want to say a special thank you to Melania, because basically it was not me, it was Melania who was the one driving this project and who made it happen and who created the checklist, etc. But what is important for you, and you see if you go to our Jus Laboris website, you will see that we have organized, I think it's around 7 matters with different topics, and where we have allocated also colors in order for you to know whether it is mandatory or recommended or forbidden, etc., etc. And the things we have considered or that we look at in those checklists is what are your administrative obligations, what about employment contracts, what about policies, health and safety, what about corporate taxes, immigration, and so forth. So this is all a checklist with different colors where you can then see whether things are mandatory, recommended, forbidden, and so forth. And what we have done then at the end, or I would say it's again Melania's work, so thank you for that, is we have allocated scores based on the answers that have been given, and the countries have been given a color based on whether or not there are a lot of things that are mandatory compared to other things which are just recommended and very flexible. And it goes from green to red. So there what you see on the slide there is a kind of conclusion, overall conclusion based on that checklist to know whether the country is quite flexible in its approach, and things which are mandatory, which are then the green ones. And the good news is, Roberta, you are a green one. Switzerland is a green, same as Sweden, Canada, and Mexico. And then at the very other end of the spectrum, we have the red ones, which are quite unflexible. And I'm very ashamed, but unfortunately, Belgium is a red one together with Chile. And then we have 2 intermediate ones, the yellow ones, which are more like the greens. And there, Melania, it's Spain and Italy. And then we also have orange ones, which are more like us, the Belgians, towards red and orange, for example, France, Luxembourg, and Austria. So, but it gives a very interesting tool for you if you consider hiring an employee overseas, that you can have a first look at different topics to know, is that required, is that recommended, can I do that? For example, employer of record, you really have there forbidden, not forbidden, possible, etc. So that is one of the things we have done. If you then can, I continue with my promotion. If we then go on the next slide. Just as an example, what we also do, and again, you can go to our website. Every 2 months, we provide an immigration and global mobility update. So it are short updates from what has happened in the law, but also case law or positions from the authorities globally. And we do that every 2 months if something has happened in the last 2 months. On an average, we always have around 20 countries. They may vary because obviously not everywhere, every 2 months something new happens, but it's really on an ongoing basis. So if you register there, then you will also receive them. We also put them on LinkedIn, so you can follow us there as well.